Hello, I'm Dr. Daria Sharkova, and today we have a new episode of our webinars. Houston, we have a solution, this time with ICDR AAA President, Vice President, probably President one day, why not? Yanett Quiroz Valdovinos. Yanett, please tell us, how did you end up in Houston?
Well, first of all, thank you, Daria, for the quick promotion and and thank you for having me here today. I really appreciate the opportunity. And I just want to make a quick comment. Some time ago, Enrique Jaramillo, who you know very well, and I were talking about how we could push Houston to be a more noticeable place of arbitration. And I congratulate you for this initiative because I think that goes in that line. So congratulations, Troy. So it's been a journey, I have to say. So I started working in a Mexican arbitration institution back in 2006. And because the ICDR has been always very interested in being close to the Mexican arbitration market, they signed a cooperation agreement with this institution back in the past. To be honest, I don't remember the exact date, but it has come for many years now. And when I joined Canaco, which is the Mexico City Chamber of Commerce that has this mediation and arbitration commission, I met the ICDR at the same time. Steve Anderson, who was the vice president for the ICDR at that time, basically trained me in how to talk about arbitration and mediation. I'm still very grateful of what he did for me in terms of teaching me all that I know. and that's when everything started. Several years after that, I left Canaco to join a law firm. And then just a few months after, ICDR invited me to join the office they were opening in Houston. I have to be honest, I always thought about ICDR very closely, but New York, which is where the ICDR headquarters are located, was not really an option for me to move. Being raised and born in Mexico City, New York was not exactly my desired place to be. But when the opportunity in Houston opened, I said, like, well, it's kind of a different environment, and I'll definitely try it. So that's how I end up in Houston. My thought was that I would come here for probably 3 years just to learn how arbitration was in the US and how the ICDR was actually working. But it's been almost 11 years since then. So the 3 years went a little bit longer, as you can see.
And we are very lucky to have Yanett today because we will speak about the advantages of ICDR AAA arbitration rules in disputes involving North American parties. And if you have some people who are not familiar with North America is Canada, United States, and Mexico. I know some people sometimes confuse and think that Mexico is Central America, but Mexico is North America. So Yanett, tell us a little bit more about the ICDR AAA arbitration rules and how they reflect their North American roots.
Well, I have to tell you, and let me go back into history a little bit. So, ICDR is part of the American Arbitration Association, which was created almost 100 years ago in 1926. And what happened is that back in those days, the AAA started to get international cases or cases with international background. And the arbitration system in the US, it's one thing. It works with its rules. Courts are very supportive, and they have their own kind of design, I would say. Once the AAA realized that they had all these cases with different needs and different culture, different backgrounds, that's when they decided to create a new set of rules that were actually international in philosophy and roots, I would say. So the thing is that even when ICDR came out from the AAA, I think it really shows an international background and philosophy. First of all, the rules were created following the UNCITRAL model. And nowadays, I can tell you that in my perspective, and I might be a little biased, obviously, but from what I've seen and from what I know from other rules, the ICDR rules are the ones that better combine practices from both civil law and common law. Mm-hmm. Why am I saying this? I'm a civil law lawyer, so when I came to the US and I started working on cases, because that was my first role at the ICDR, I realized that you can start a case without a document. What is that? I mean, in a civil law country, it would even be unethical to advise your client to commence a case without a single document. That it's actually possible under common law, right? And the fact that the ICDR rules put together this provision in the rules that allows the parties to request production of documents, but with limited capacity. It's a really, adoption of a practice that will definitely benefit the parties in the process, because even if you are not familiar with it, you can take advantage of that provision. On the other hand, we are very used to written testimonies in civil law countries, right? It's the way we present evidence before courts. That's not the case in the US. Here you have subpoenas, you have interrogatories and other figures. The ICDR rules actually indicate that the preferred method of presenting witnesses is in written statements. So these are just two examples of how the rules actually combine figures of both systems and to enhance the arbitration process. And that is why I think that even when the ICDR rules come from the background of being part of the AAA, it came out from that attachment, and it's now a set of rules, an independent set of rules that actually provides for a global integrative provisions that allow the parties to benefit from both systems.
That's very interesting. Actually, Yanett answered the question I wanted to ask about the common law discovery and its relationship to ICDR rules. But are there any safeguards against the abuse of this common law discovery process? Some Americans, they really love the discovery, right? So are there any safeguards in the rules kind of to balance that?
Right. Well, the provision itself, it's an effort to do it. We will always find abuse. I mean, it's lawyers, we become creative. I think it's part of our nature, and it's how, it's how we were trained, right? To be creative, to defend our clients. But two things are critical in the production of documents that the ICDR rules provide. And one is that you have to indicate a time frame for the documents that have to be produced. So you can ask for all the documents through the whole life of the contract or stuff like that. It has to be identified and it has to be relevant. So whenever the parties request production of documents to arbitrators under our rules, they will have to justify under these two conditions, and then the tribunal has the basis to deny or approve according to the same rules.
Very good. What trends are emerging in ICDR cases related to the North American parties? What are the main industries, sectors, types of disputes?
Right. So, well, can you imagine, most of our cases are related to U.S. parties. We are still identified as a amicable, sets of rules or system for U.S. companies, and we are perfectly fine with that. But we also want to let parties from other nationalities know that this combination of rules and of practices are really familiar to anyone. So don't be afraid of using them, because you may be surprised of how useful they are. Also, our case management team is compiled of very talented lawyers from different jurisdictions, and I can be more proud of the team that I have. They are very, very experienced, very professional, and they know how arbitration works in different jurisdictions. So again, a very good reason to try to use our administration. In terms of other parties, Canada has been the second nationality in our caseload for several years. Obviously, the economic nexus can be denied, so we are very connected to Canada. And from there, I think other countries have been more relevant from year to year. China has been very important for the past few years. Mexico, Mexico has its own, way to work, and I can say that because I'm from Mexico, so I can.
Yes, finally we have a Mexican speaking about Mexico.
So I can criticize a little bit my own country. That's no problem there. But we've been having a pretty good decent number of cases with Mexican parties so far. Not as many as we would like. But we're still working on that, and we are very confident that may change in the future with everything that is going on there in terms of courts and decision of disputes and all of that. But that's what I can tell you in terms of nationalities. In terms of sectors, technology has been one of the main ones for like the past 3 years or so. But there are also other sectors that are very important. Right now, we are pushing hard to increase our energy caseload. With me being here in Houston and everything that is going on in the world, we think it makes sense for us to try to put together a better offer for energy companies in our proceedings.
Do you have rules translated into Spanish?
Yeah, definitely.
So for Mexican parties.
Yeah, right? We actually have several languages, and I'm sorry that I don't have all of them in my head, but if you go to the website, you will be able to see a list of all the languages that we have. And obviously Spanish is one of them, but we even have, I think, Arabic, Chinese, and many others. When we amended the rules in 2021, at the same time, we put together several committees from different countries, so we could have all the rules translated in different languages.
Can Mexican parties use ICDR rules for their internal disputes? Are there any kind of disputes Mexican parties can use the rules for?
Definitely. I mean, there's no prohibition in doing that. The only thing, and one thing that I always say is that you have to keep things in perspective, right? Mexico has a certain economy, and I don't know if that's still the case, but a few years ago, the medium and small companies were the main supporters of the Mexican economy. So there might be disputes there that, just because of the cost and other things, it doesn't probably make sense to bring them to the ICDR rules. And there are many other institutions, domestic institutions in Mexico that may make more sense for those. And that is part why the ICDR had that cooperation agreement with Canaco, because part of that agreement was to promote Canaco for domestic cases and ICDR for international. We obviously understand that things have changed, and there might be cases in Mexico that are very complex that definitely need a better structured institution to manage their cases, and that's where we can offer that service. But there might be others that are very small, and those may made more sense for
It's
domestic
expensive to
case.
bring
Yeah.
for ICDR, right?
The other thing that I can mention is that with all these technology that we are implementing in our cases and our purpose of, putting some of the cases under the administration of the ICDR using AI and stuff like that, I wouldn't be surprised that in a few years it would make sense to bring even small cases to the
Because it will
ICDR.
drive the price, the cost
Right.
of arbitration down. And what about, for instance, the cases? I know that there is a lot of investment of Chinese parties now in Latin America and in Mexico. So maybe that's the case good case for ICDR rules, right? The Chinese company investing in Mexico, that may be an option to include the ICDR rules.
Yeah, no, definitely. And another reason is that we have an office in Singapore, and we named that office, and like a main center is the Asia Center of the Case Management Center, and we have, let's say, that part of the world covered with this office and this center, and we are in the process of getting one person in China just to be closer to that market. So I think it would definitely make sense.
Thank you. Coming back to the rules themselves, do they contain any similarities with the US legal proceedings before the courts? What are the advantages in comparison to the US proceedings?
I think not too many. I think the principles of arbitration are very well drafted in the rules. We try, as I said, to prevent abuse from court litigation in arbitration, and those are very clear in the rules. Even for domestic rules, I can tell you that, for example, AAA's commercial arbitration rules that were amended a couple of years ago, they actually adopted some of the provisions of the ICDR rules because, they are really important and relevant. And one of the things that the AAA's commercial rules state is that interrogatories and depositions are not advisable or the best practice for arbitration, even domestically. So we are really trying hard to get away from court practices to make arbitration a really more effective mechanism for dispute resolution.
Can party opt out of this Americanized style options like discovery or depositions, or it will be still included in the rules?
No, the rules are pretty clear that those are not included. So if they would like to include them, they would have to create a process in that regard, right? And again, arbitration is flexible. So if the parties are comfortable with using those formulas for the process, they can definitely state that in a procedural order. The arbitrator will have the last call in allowing the parties to do that. I have experience here. I had a case where a very well-known international arbitrator, and if she's listening to this, she will know which case I'm talking about. There were two US lawyers, not very familiar with arbitration, and
litigators.
Litigators. They come to the procedural hearing and they start discussing about what they want, and they start to say, okay, we want like 10 depositions, and no, not 10, 15, and they start arguing about how many, and then the arbitrator stopped them and started giving them a speech of about, 20 minutes, why those were not recommended for arbitration, trying to convince them that they was not the right way to do it. I really appreciated the exercise that the arbitrator tried, because that's exactly what is this about. Avoid all these practices. But at the end of the day, the parties agreed to have less than their starting point. So at least she succeeded a little bit. But in any event, the parties decided to move forward with that type of case, and again, arbitration is flexible. The rules allow that flexibility if that's what the parties want. But if they don't, and there is some contentious between the parties because of this topic, the rules support the idea that those are not the right figures or formulas for an ICDR arbitration process.
So comparing to other institutions' rules, some institutions don't allow any additions, any changes into the rules, so you take them or leave them. Does ICDR allow changes and additions by the parties? Should it be written in the contract, or how normally it happens?
Yeah, the rules are very flexible within its own text. So if the parties want to make any changes to the rules, they can do it. And they can do it just by the procedural order or, other means. It doesn't have to be in the contract, and unless it's very needed and specific, we would not advise to go too far away from the model clause. Even though we right now have an AI clause builder that may help you to, better tailor your arbitration clause if that's what you want. But in those specific issues, I think my recommendation would be just wait for the dispute to come and see what are actually the needs of the parties in the dispute, and then make any modifications to the rules in the procedural order after having discussed this with the tribunal.
Does ICDR administer the rules of other institutions, or for instance, ancestral rules? Because if we compare to the ICC doesn't allow any other rules to be brought to them. They will just not take this case. Is ICDR more flexible in this respect?
Yes, we only administer UNCITRAL rules,
but
because
that's a lot already.
Yeah, because those are not administered proceedings, right?
Mhm.
So we can take those if the parties want that. We can also serve as the appointing authority for UNCITRAL proceedings. So even let's say partial administration or full administration, we can offer those services. And what we are trying here is just to be, as flexible as the parties need us to be, right? I will take the opportunity to make a quick comment, because, I've realized after being part of two different institutions and knowing the rules and basically the rules, which is the thing that the parties know and see from the outset. I would say that, if you go to the rules, you can find some differences, but they are pretty much similar, right? I mean,
A lot of rules are similar.
yeah, they are. I mean, there might be some provisions that makes them different, but from my perspective, what really makes different one rules from the other and one institution from the other is the philosophy and what's behind the rules and the administration.
The efficiency, that's what party wants, right? Party want efficiency and be cost, like not very expensive.
Effective, yeah. And you know what I've noticed in the ICDR is that us as case administrators, we do more than the parties can see. And we are very close to the proceeding. We know what's going on in the cases. The parties can always come to us with any concerns about what the arbitrators how the arbitrators are performing. And that's a lot. I mean, if you have someone to raise your concerns to, I think that's very important. And on the other hand, we're also there to support the arbitrators in any way they need us. I've had cases where there's a 3-member tribunal, things are not going as well as they should. And we had to schedule meetings with the arbitrators just to learn what's going on and kind of mediate between even the arbitrators to make the case move forward in more expedited basis. So it's a very interesting role, and I don't think all the institutions have that.
I know that, well, probably not a lot of people know, but I was told once by Kevin Nash, by the way, that ICDR AAA were the first institution who created the emergency arbitration rules. So, for instance, if our Mexican party, let's just take this example. Mexican party, American party, no, US party, they concluded a contract. So can they, should they just put ICDR rules, or can they pick and choose, put the emergency arbitrator rules or some other rules possible into their contract? How it works?
So nowadays, the emergency arbitrator is included in the rules. As you said, in the past, there was I don't remember exactly how was it named, but it was like an extension of the rules, and the parties had to agree on that provision to be incorporated in the rules. Nowadays, that's not the case. The emergency arbitrator provision is now in the articles of the rules. So if you want to use it, you can. And that's it. You don't have to do anything else or anything in addition to just adopt the rules in the arbitration agreement.
We have a comment from Mauricio Gomes Santos. He says, I like the Article 2410 provision, very precise knowledge in the CDR rules.
Mauricio knows the rules very well.
I have already brought to the attention of the parties even when represented by US counsel, and it worked well. Okay, Yanett, now explain us, what's this Article 2410?
I think it's actually related to the production of documents. So the fact that you, it was just about what I was telling before, that the fact that the arbitrator educates a little bit the parties when they are not familiar with how this article works and the reason behind the article. I think that's where this talk from the arbitrator becomes relevant and important. And Mauricio is part of our panel, so he knows very well how to do that.
Now I understand the comment. So comment was after what Yanett said. And it's good we learned some precise numbers of articles of the CDR rules today. Another question. So it seems like ICDR rules are used by the parties, at least now, more for commercial contracts, right? Does the ICDR do anything for investment contract perspective? So just to probably encourage parties to insert the ICDR arbitration provision into the contracts with the states or government entities. Is there any possibility for that?
Yeah, we definitely have disputes or arbitrations with government entities. So there's I don't think we have anything in particular in terms of any guidelines or any focus on investment arbitration particularly, but we've definitely had cases where government entities are involved. And again, the rules are, I think they are really good. So they have been working well in those disputes. There are not few. We are having more and more. And we've also seen that, you know, maybe state-related contracts may come to in the form of commercial arbitration for other reasons. So we're very eager to get those cases and very well, I would say, suited to help parties with those too.
Thank you. What mechanism can you, now let's just go more inside the rules, because apparently we have very knowledgeable audience here. What mechanism exactly have the ICDR rules which enforce the efficiency of the arbitrators, keep the costs down, and probably facilitate the communication between parties and the arbitrators?
My favorite part of this is, and the first, I think, touch in the case is the administrative conference. I think this is like kind of this, for me as administrator, obviously, is kind of the star of the process, because you can't imagine how many times the parties haven't had any contact after a dispute arises. So there's one dispute due to a contract. They never talk. They never said anything to each other. And then our first step in the process is to schedule this administrative conference. What is the value or the importance of this conference? The first thing is that this conference is not going to be to discuss anything about the merits of the case. So this conference basically covers the constitution of the tribunal, the applicable rules, and some other administrative information that we share with the parties. So the fact that whenever you get into this conference and tell the parties, no, this is not to discuss the merits, just slow down, and we're going to talk about how to make the process efficient and help you to better resolve your actual dispute. I think that makes something to the feelings of the parties in terms of cool them down and just put them to talk about issues that will help them, as opposed to make them discuss about their problem, right? So in my perspective, that makes something, something mental, right, to the people involved. And just the fact that you start talking about, okay, let's make this as efficient as possible. We have this arbitration agreement. This is what the arbitration provision states. If there are, specific things in the arbitration clause, we will follow them, obviously. But also another important thing is that in this conference, the parties have the opportunity to agree on different things or on modifying that arbitration agreement, which is a pretty good opportunity to fix any issues that the arbitration agreement has, or even adjust the arbitration agreement if something doesn't really work for the parties at the moment that the dispute arose. So that's my favorite part. Obviously, it's the one where we play a more active role, and that's probably why I like it so much.
So it's normally the parties, is there already arbitrator in place or no arbitrator in place?
It's just the administrator of the case and the two parties. And let me go a little bit back just to probably explain a little bit better how it works for the ones that doesn't know. So whenever you file a case, either by email, through our web file, or wherever, that case is assigned to a case administrator. And that case administrator is the one that will go with you through the whole process. This is the person that will submit any administrative issues to the International Administrative Review Council. This is the person that will be with you at the administrative conference. This is the person that will schedule all the steps during the procedure. So this is a very important role, and that is also why I think it's very important in this conference, because that's where your opportunity to get together with your case administrator and kind of build this relationship with the parties. That's the opportunity. So yeah, that is one. The other one is the opportunity that parties have to participate in the appointment of the tribunal. We obviously always honor the parties' desire to appoint their own arbitrator, but even with that, we are always interested in assisting the parties if they need to in that appointment. So we have a panel of arbitrators, people that we have trained, people that we trust, people that know our system, and we will either propose those arbitrators as candidates for the case if the parties want that and make the appointment through a list, or we can also make what we call a reference list, which is just bring those names or names from several people to the parties so they can make their selection. And I think that helps two purposes. One is the parties to make a better informed decision, not always go with the usual suspects, as we call them, and even consider new names or new people that are arbitrators for, if not for that case, even for future cases. So, and on the other hand, arbitrators that know well, again, our system and our philosophy, they can be more visible for the parties in all of our cases.
I think, we have a lot of questions. Okay, a question from Leonore Jacquemet. Sorry if I pronounce it in a French way. I know it's not French person. What is your unique selling point? What makes you unique in comparison with other arbitration institutions? I think Yanett told us a lot about the best points she likes about the rules, but do you have any other unique?
Yeah, I would say I don't think it's a selling point. I will see it more like a differentiation in our service. And I would say probably the valuable team of administrators that we have and the level of service that we provide both to the parties and the arbitrators during the process.
Thank you. Another question, Marco Abruzzi. Great webinar. Thank you, Marco. Does the ICDR have a draft procedural order number 1 to circulate to the parties before the first procedural conference?
So we don't have a draft. What we have is a list of topics that we expect the arbitrator to cover with the parties during this procedural hearing. Both parties and the arbitrator have this list, so they know what they are expected to discuss. And the reason we haven't made a draft is because we still believe that every case is different. And, arbitrators from time to time, they create their own templates and they use them. But from what I've seen in cases, I would say that arbitrators need to be very careful with this, because there might be things that not really fit for the specific case. And I've seen that sometimes arbitrators that are very well known, very used to big cases, complicated cases, they adopt these templates for cases that are not actually fit in that type of case. So, and that brings some sort of, frustration to the parties, because it looks from the other side that things that wouldn't be that complicated are really being complicated. So yeah, I would say we need to keep things in perspective. Just create your own template as an arbitrator, but also be careful with that and adjust according to the arbitration, to the specific dispute. Because, let's go back to the basics. One of the main values of arbitration is its flexibility, and the fact that you can create a proceeding according to the specific dispute. So let's don't lose that from our minds.
And also the cost efficiency, right? Can you explain us more about cost? How does it work? Does the ICDR have some kind of filing fee? What's the administrative fee of ICDR? What are the fees of arbitrators? Are they like at the ICC? Do they depend on the amount of dispute, or do they depend on the hours the arbitrators spend? So could you please explain more?
Sure. So yeah, there's a filing fee to initiate a case with the ICDR. An interesting thing, and something that maybe not very well known, is that our fees are divided into different stages. One is when you initiate the case. So depending on the amount of the claim, you will pay that initial filing fee. And once the hearing, or a hearing on the merits, or a hearing that can decide the case is set, we have a second part of that fee. So if for some reason the hearing doesn't happen, just because, the parties settle the case, or they decide not to have a hearing and they just move forward with a decision on the documents, then that fee, that second part of the fee, will be reimbursed to the party that pay it, depending on the time frame. So that is, I think, important, because we've seen that many of our cases settle even before the hearing. So that makes you feel that you can save some money if you have an efficient dispute resolution process. In terms of the arbitrators' fees, we pay the arbitrators by hour. And I know that many of the civil law lawyers would say, how can you do that? It's not predictable. It lacks of certainty, because you don't know how the proceeding is gonna cost. Yes and no. Maybe you don't have that predictability, but even with that, you have other advantages of having that. One is the arbitrators are more invited to be efficient, because they're going to be paid from the actual time that they invest in the arbitration proceeding. Meaning that it doesn't matter if the arbitration proceeding lasts 2 years, 3 years, 5 years, you're going to still be paid for the same amount. in our system, the arbitrators will be paid for what exactly they worked in the case. And actually, the parties have access to the invoices and the relation of times and activities that the arbitrators did during the process to be charging for those fees. We have also very specific guidelines telling the arbitrators what they can bill and they cannot bill to the parties. For example, communications with the administrator are not billable to the parties. So that gives us a little bit of more control over the costs of the arbitration proceeding. And on the other hand, the parties also have more tools to save money, because if they agree on several things during the arbitration process, for example, I've seen cases where the arbitrators ask the parties, you agree on dates, you submit a draft scheduling order, and we will just discuss this during the procedural hearing. If the parties do that, they will save lots of time from the arbitrators in that exercise, and that gives the parties control over the cost that they are, expending. Obviously, if the parties are contesting every single thing during the process, that will cost them money. But again, it's a system where I think you can have more control. Now, with the implementation of all this technology and all these tools that we are testing and providing to the arbitrators, that also goes in the same line, right? To give the arbitrators opportunities to reduce the costs because their work will be more efficient. So I think it goes on the same line of thought of having the parties or giving the parties more control over what they are spending. When you have a fixed rate or a fixed amount of arbitrators' fees, I think they are not that pushed to be more efficient. It doesn't matter how much you spend or how much you work, you're going to still be paid for the same amount. So I don't know. I know people can argue against that, but those are the advantages that we presume this system has for the parties.
I think the fact that they can contest the hours, that saves the system in the sense that party will not think that the arbitrator can spend 5 hours on drafting a 1-page procedural order, right?
Right.
So
And that's
yeah.
And just in addition to that, whenever an arbitrator submits an invoice, we also make a review of that invoice. So there's some discussion there too, in terms of, okay, if an arbitrator submits an invoice for 40 hours in a week, it means that the arbitrator is dealing like a complete work day in that case. I don't think, that needs to be explained, right? It needs to make sense also in terms of where the procedure is, how things have been working within the arbitration, and that it's also a discussion the case administrator may have with the arbitrator if that's needed.
That's a great possibility to control the costs. We have one more question. I don't know how to pronounce the name, so excuse me. Kojo Tabiri. What is ICDR's plan and reach with regards to the African legal and commercial market? Very interesting. Are there plans to engage with the African continental free trade area, especially arbitration and mediation of cross-border commercial disputes in Africa? Other institutions that taken over Africa, but ICDR is almost non-existent. And I think that Yanett will give a good answer to that.
Yeah, well, it's the word is really big. So we are trying to be strategic on where we are present and try to cover our caseload needs. There's obviously new markets that need to be open, and my recommendation here is if you have any opportunities we can take advantage of, we're always open to take them. So don't feel free to reach out to us and just build community if that's what we can do. We are very open to that. We obviously want to develop different markets and different countries obviously with our caseload. But again, we are a nonprofit institution, so we have unfortunately limited resources. So we need to be very cognizant of where and when we expand our resources in certain jurisdictions or places. But again, definitely open to have a discussion and to take advantage of any opportunities that you think would be good for the ICDR.
And here in Houston, we have a Yanett's colleague who is from Nigeria, so that may be an option.
That's true.
That's a question
true.
for her, not for Yanett.
Yeah, maybe we can ask. So Chintima on the Jelabalu, I hope I pronounce her name correctly. She is the new AAA's vice president for the commercial division, and I know she's being very close to some initiatives. Actually, now that you mentioned that, Daria, I remember that we had an arbitrators training last year, or no. I'm like, it was earlier this year in Africa. So there's been some activities there, and we have taken a look to what we can do there. But again, in terms of resources, we need to be strategic.
And also the parties now, when they know that the ICDR rules have some advantages in efficiency and cost saving, parties can start inserting the arbitration clause in their contracts, and I don't think ICDR will refuse.
No, not at all. We'll be very happy.
We have already spoken for 45 minutes, so nice. Well, not nice. Everything is nice. My favorite part of the webinar. What are your favorite places in Houston to bring your clients and friends? Are there any good Mexican restaurants?
Oh my God, I have to confess something. So I'm terrible with places in Houston, just because every time I have the opportunity, I look for Mexican restaurants. So that's terrible, because when people come to visit, they always ask, like, what's the best place in Houston? And I always suggest Houston Mexican restaurants to people coming from Mexico, which is not very wise. But
what are these Mexican restaurants? Tell us.
So Sochi is one that it's really good. Caracol, it's another one.
These are very fancy ones.
Yeah,
Fancy
those are my favorites, to be honest. I think those are the ones that I would mention. There are others. Ugo's is good. I don't love it. Sorry. But in terms of good restaurants in Houston, yeah, I think those are my favorites. And there's another one, and I'm terrible with names. I'm very sorry, but we just went to
Is it
one.
Mexican or not?
No, it's not Mexican.
That's not a Mexican.
It's a really good one at the Galleria. It's actually Indian food, and the name makes reference to a person that travels all around the world. Do you know? No. It's a really good one. Just take a look on.
You can write it Yanett, and she will research and answer.
I can share the name later, but it's a really good restaurant. It has this Michelin recognition. And I just went there with my husband for our anniversary, and it was really, really good. So I recommend.
Congratulations on the anniversary.
11 years, so.
So we can take another question or two if somebody's interested in something in particular. Otherwise, can I ask as a last question? What do you see as a future of ICDR in relation to the North American parties? What are the main tendencies now for you?
That's an interesting question. So from my previous role at the ICDR, as I said, I was more involved with administration of cases. And for natural reasons, I was involved with cases in Central and West US and also Mexico. But I was not very familiar with Canadian cases, for example. And what I can tell you is that in the past few months, I realized that Canada, it's a very interesting market in terms of arbitration practice. They are very used to ad hoc arbitration and semi-administered arbitration. So arbitrators are very, very sophisticated and they know how to deal with cases. But there's also a need from the users to have a little bit more control over the proceedings. So that is something that I see and that I think might change in the future. So maybe more room for administered arbitration will happen in Canada because of this. I don't know how far the concern of arbitrators' appointment has raised. I haven't get there yet. But yeah, I can tell that from the party's perspective in terms of how to manage the proceeding, there's a need there that needs to be addressed. ICDR created the ICDR Canada rules a few years ago to cover that market. The rules are very similar to ICDR with a little bit of, clinches that adjust them to the Canadian market. So I think it's a good opportunity for Canadian parties to take a look to those rules. In the US, I think, I think the AAA and ICDR is the main institution with no question, right? The AAA administered more than 530,000 cases last year, and that's not a coincidence. We have a very good reputation and tradition there, so I think that our caseload here will remain in the same tend to increase cases and all of that. And Mexico is a completely different story, right? Well, not different, but it has its own
Everybody wants to
story.
speak about Mexico now.
So you know what? I think what is going on in Mexico right now is that I can tell you, I started in Canaco almost 20 years ago. It was very disturbing to me to go back to Mexico and see that the caseload, generally speaking, in arbitration has not increased in any proportion to what we see in courts. So courts are really, really overwhelmed with cases, and arbitration cases, even with ICC cases having a good presence in Mexico, there are not that many cases as they should be. So everything that is going on right now with the court system, I think it brings a good opportunity, mostly for practitioners to turn their heads to a different option in arbitration, which didn't happen in the past. Lawyers were very comfortable litigating cases in courts. So that is part of why arbitration didn't have that popularity in litigation. So I think that creates a very good opportunity. If it will actually become in more arbitration cases, I'm not exactly sure, because as you know, in order to have a good arbitration system, we need the support of a really good court system. And I'm not sure where Mexico is going on that. So maybe there are going to be more clauses, maybe there are going to be more cases, but it's also true that if we have a lack of judicial support to arbitration, that is going to create an issue. And I don't know how that it's going to play in the actual arbitration work. So I think those are my insights from the North America market. I think lots of things are happening in Latin America. I just heard a very quickly overview of what's going on in Peru, Bolivia, Venezuela, Colombia this morning, and it's a thing. Big things are happening everywhere, so we need to keep an eye on that. And as a community, I think we need to keep doing what we do, resolving disputes and doing it the best way we can. But yeah, I think arbitration is gonna increase. The practice is gonna extend, And we just need to be knowledgeable of that and support the new users so they can have a good experience and keep using arbitration because they want it, not just because they have to.
Thank you so much, Yanett. That's very, very interesting perspective. And actually, it's true. Mexico, what's happening in Mexico, it's not only the bad, it's also the good for the arbitral institutions. Thank you so much, everybody who stayed with us for more than 45 minutes. If you want to watch it again, it will be on the special page on YouTube and hopefully as a podcast. Thank you
Great.
and have a nice day.
Thank you.